This session is now resumed. Prior to the suspension, we were debating a bill to amend the Constitution. To that, we shall revert. Honourable Member for St. James North.
Thank you, Mr. Speaker. I rise to support these two basic amendments to the Constitution of Barbados: the establishment of a Protective Service Commission to replace the Police Service Commission, and the establishment of a General and Administrative Services Commission. The historical basis, sir, of the concept of Public Services Commission came from 1950 United Kingdom White Paper, which sought to establish service commissions which were impartial and free from political interference in terms of the composition of them. As a colony, sir, we would have had the basic tenets of it, whereby the governor of the day, appointed of course from the United Kingdom, was responsible for appointments to the public service. Of course, we then had our Constitution in 1966, which set up public service commissions, police service commission, and essentially entrenched them in the Constitution. And also the Judicial and Legal Service Commission, which would have dealt with judicial appointments of judges, sir. In 1975, of course, we know that the then government of the Right Excellent Errol Barrow would have established a Teachers Service Commission, sir, which in fact never became established until 2017, when the last administration then proclaimed that aspect of the Constitution amendment in 1975, but never appointed any Teachers Service Commission, and therefore, 45 years after, almost 45 years after Teachers Service Commission was established, we still don't have one. In 1998, of course, the commission headed by Sir Henry Ford, sir, as the Honourable Member who last spoke, the Honourable Member for Christchurch, St. Michael, West Central, said, would have had a wide mandate to look at our Constitution and see what changes would be recommended, constitutional changes. And that commission looked, among other things, at the Public Service Commission and how we could make it more efficient in terms of its delivery to the public and in terms of those who were the public servants working under it. That Sir Henry Commission, sir, was also mandated to look at issues such as the right of recall of members of Parliament and the role and powers of the head of state, whether we should have a Republican constitution and a president, and also looked at our fundamental rights. A lot of the recommendations of that commission have not yet been brought into force. I know that one set of recommendations that has been, though, sir, was to remove some of the gender bias in terms of our immigration legislation, whereby, for instance, a man who married a Barbadian citizen was not entitled to Barbadian citizenship, but a woman married to a Barbadian citizen was entitled. And coming out of the Ford Commission, so that legislative change was made to remove that gender imbalance. But one of the main recommendations of that commission, sir, was that we should establish a protective service commission under which the fire service, prison service, police service should fall. And therefore what we are doing, as the Honourable Member for St. Peter said in his contribution, is bringing into force an entity whose time has come, sir, and in fact whose time probably had come a long time ago. Because right now we have this amalgam of a public service commission under which, 25,000 odd persons, public servants fall under. As the Honourable Prime Minister said, meeting generally once a week to deal with matters of discipline, of appointment, of suspension, all matters, and really and truly that's absolutely impractical. And therefore, this legislative intervention by Parliament tonight, sir, is to establish a protective service commission under which 4,000 odd public servants will fall, in addition to the police, the fire, and prisons, which were recommended by the Sir Henry Ford Commission, sir, immigration, public officers, customs officers, and security guards under the Ministry of Defence would also fall. Now, sir, it is contemplated, and certainly, sir, with the setup would bring great efficiency, speedier decision-making in terms of the public servants falling under this commission. And immigration, of course, right now has about 175 employees, customs, roughly 257, fire, about 239, the prisons, about 386 employees. I know police has about 1,250 odd. So this would bring great efficiency. The proposal is to set up full-time secretariats, sir, which will be able to deal with the human resource management, because of course these commissions are similar to a human resource department of major companies. The human resource experts in here would say, like the Honourable Member for St. Peter and the Honourable Member for St. Michael, West Central. And this is part of modernizing our whole bureaucratic system, sir, which has been, I think we all accept, slow to deliver to the public and to itself. And it is part of the ease of doing business, part of making Barbados more competitive, which is something which we have absolutely to do to be able to move forward in our development as a whole, sir. The creation of a Protective Service Commission has been supported by the unions, sir. When you look at the files, you see the unions, Setusab, calling for it for a while, for well over 5 years. I would have had meetings in July last year with the police, the prisons, fire, customs, immigration, chief personnel officer, representatives of the Ministry of Civil Service, in terms of the feasibility of establishing the Protective Service Commission. All were in agreement, sir, and felt that it'll make the whole system more transparent and accountable. And therefore, I'm fully supportive of the abolition of the Police Service Commission and bringing in these protective forces. That's what they have in common with one another, essentially protective border security forces under one commission. This, of course, will take these departments out of the administrative commission, Administrative and General Services Commission, sir. That commission will now have less public servants under its mandate, something which is essential for greater efficiency, the Administrative, General and Professional Services Commission, and this commission will replace the Public Service Commission. And we look forward to, therefore, an exciting period in terms of greater efficiency in the human resource management of government. There has been a tradition where matters of discipline, suspension of public officers have taken years to be resolved, years to be heard by the Public Service Commission. Appointments of public officers outstanding for a long time, sir. We heard the Honourable Member for St. Michael West Central speak extremely eloquently on the difficulties which the qualification orders which were brought in by the previous administration 3 years ago have caused throughout the civil service, sir. And I'm absolutely aware of this because the departments fall in under my ministry, about 9 of them, all internal affairs departments, and every time you have a meeting with representatives or management of these departments, you hear about the difficulties of these qualification orders, the fact that officers who are acting in positions for years are not eligible for appointment to these positions because they may not have reached a certain academic qualification grade which these qualification orders now set out, when clearly perhaps those officers should have been grandfathered in, even if you wanted to carry on this higher distinctive academic qualification requirement for future, sir. And I believe, sir, that the Honourable Prime Minister is committed to looking at, as Minister of the Civil Service, committed to re-looking at those qualifications orders, sir, because the Prime Minister, Honourable Prime Minister, and this government is clearly mindful of the trauma that this legislative intervention by the last government has clearly brought to people all across Barbados in all the ministries, sir. So we are happy to give support to this. We are happy that the Honourable Leader of the Opposition has found it fit to support this amendment, and we are aware, sir, that the unions, the labour movement, is also supportive of this amendment, sir. The other aspect of this bill to amend the Constitution, of course, relates to the judges, sir, and the provision that judges deliver judgments within 6 months, and that if they don't, it could trigger proceedings, sir. It's not automatic, as the Honourable Prime Minister absolutely clarified and explained. It's not an automatic part of the bill that they would be dismissed because of failure to deliver judgment, but it triggers a process and tribunal hearings, sir, as to why they have not delivered the judgment. This is something, sir, that we have spoken of in this session already, when we passed legislation to provide for more judges, and there's no reason whatsoever why any judge who is suitably qualified for that position can't deliver a judgment within 6 months, sir. They have the transcription facilities, the judicial assistance to help, the management tools, sir. As I understand it, they get training in writing judgments, continuous training. We have the technology and the video recording of the proceedings, sir. And as I always say, sir, the best time to deliver a judgment is right after the case, when all the evidence is fresh in your mind. So I've served in judicial capacities as chairman of the Severance Payments Tribunal, 20 odd years ago and more. And that's the best time when the evidence is fresh in your mind. And the judges signed on to a code of conduct many years ago that their judgment should be delivered within 8 months. As the Honourable Prime Minister said, Guyana passed constitutional amendment in 2001 on this issue, that judges must deliver judgments within 6 months. Guyana then went further and passed legislation which limited the time that judges must take to deliver judgments within 6 months. And here as well, we're making provision if the judges feel that they can't deliver the judgment within 6 months, go to the Chief Justice and give reasons. And the Chief Justice, under those circumstances, would probably give you time to write the judgment, sir. But it can't go on like how it has become within recent times, where there are judges that have outstanding decisions for 5, 6, 7 years. Some retire, sir, without giving the judgments, and they get the gratuity, sir, which, quite frankly, is up to question as to whether you should get your gratuity if you have outstanding decisions. Some died and gone long, sir, without rendering the decisions and leaving the parties to the case in absolute limbo. Because what you're going to do, you're going to have to look for more money to pay now to get the cases reheard. You're so frustrated, sir. And all of this has to do, again, with making Barbados competitive, not only in the commercial sector area, sir, in terms of commercial courts, where, of course, speed and delivery of judgments is so important, but in other areas of civil law, sir, where parties are at a limbo, and there's therefore a socio-economic cost to our constituents because of judges' unreasonable delay in giving judgment, sir. We're here trying to help the judges themselves, sir, because judges have to be accountable. It can't be that because you are appointed to high judicial office, you are a law unto yourselves, sir, and they have to be accountable for their conduct and for their manner. And all this is doing, sir, and very reasonably and sensibly so, sir, is making failure to deliver judgments within a 6 months period, which is reasonable time, sir, a possible ground for dismissal of a judge, but after due process, sir, tribunal hearing and everything else. And I'm fully supportive, sir, of both of these amendments which have been brought here before this Parliament this evening. I'm obliged to you, sir.
Honourable Member for Christchurch East.
Mr. Speaker, I don't propose to detain this Honourable House unless provoked.
By whom, Honourable Member?
By the rumblings and grumblings from the other side, sir.
From the other side?
The other side.
The opposition side, Honourable Member?
Well, I have to question that, sir. But, sir, other members have spoken in detail and well, in particular on the Public Service Commission. The Prime Minister herself, the Honourable Prime Minister, has indeed addressed the matter of the Service Commission, sir. So I will just concentrate on the judiciary and the amendment that affects the judiciary. I think it's necessary, sir, in certain things to contextualize why we have to do what it is that we have to do. And when you put in a time frame, explain why we're putting in such a time frame. Sir, we recently made some amendments to the Supreme Court Judicature Act. And we're appointing more judges. There are more courts being created. We're segregating into divisions, specialized divisions of the court, all aimed at increasing the efficiency of the court. We have finally codified the Latimer House principles, sir, that are considered now the best practice in the Commonwealth and perhaps in the world for the appointment of judges to ensure the independence of the judiciary and the separation of powers. And while we were downstairs just now having dinner, the installation of Andrew Burgess, former Justice of Appeal in Barbados, Andrew Burgess, now a judge of the CCJ, was going on. And the Honourable Mr. Justice Saunders, who is the President of the Court, was explaining the process by which they arrived at the selection of Justice Burgess. It was an internationally advertised post. The vacancy was created when the former president retired. Justice Saunders was elevated to the position of president, and a vacancy was created for another Justice of Appeal in the CCJ. It was advertised internationally. They had applicants from New Zealand, Botswana, Jamaica, Belize, Guyana, Barbados. I think there were 20-something applicants for that one post. It was shortlisted down to 8 people. And the shortlisted people had to present an extensive dossier on the cases that they had done and explain why they should be chosen above anybody else. And out of that, our own Andrew Burgess, former Dean of the Faculty of Law, lecturer at the University of the West Indies, he was selected. So there was some dispute. When we had codified the Latham House principles, some people were saying, if we open to international judges, then we might not ever get another Barbadian judge on our own court. So just to put that to lie, the fact is the CCJ went fully international, and a Barbadian was still deemed to be the top of the pack in the selection of the judge, the next judge for the CCJ. So that points towards what we have in Barbados and the level of jurisprudence that we have in Barbados, something that we can be proud of. So all of this has been going on in the last year, led by the Honourable Attorney General, the member for St. Joseph. We've put in place that regime designed to secure the independence of the judiciary in Barbados, to remove the political, as much of the political aspect as practicable from the decision-making process, to make sure you don't have prime ministers appointing their friends or spouses or close associates as favors and diluting the courts with incompetent people. So we've put that in place now. I expect that the next set of judges to staff the expanded court system will be appointed in accordance with the Latham House principles. That's the assurance that we have gotten, and I believe that it's the law. And that, sir, is a good thing. So we are protecting the public by creating more independent judges, setting the framework for the independence of the judiciary. We are protecting the judges so that the most suitable judges can get it on merit as opposed to political patronage. So now, to be honest, sir, we are laying the framework for the revolution of the court system in Barbados. We have accepted that for Barbados to go forward, our court system needs a radical overhaul. We have perhaps made the largest investment in the court system outside the Barbados Water Authority building, sir. Sorry, I couldn't resist that one. In the creation of the Supreme Court, we've supported the court with the infrastructure. The court is technologically advanced. The court has everything it needs now to function properly. And so do the judges. It is now time for the judges to give something back. It makes no sense to have a new court system, a new method of selecting judges, new courts, specialized courts, and still have the same old practices that ran us into problems in the first place. Sir, the backlog will not come down in the court system unless judgments are coming out effectively faster than cases are going in. We're not going to get it. It's simple mathematics. What is coming out must be more than what is going in for it to reduce. Now, sir, I have heard some rumblings that 6 months is too short a time frame. A judge is someone who is appointed to decide a matter. At the end of the trial, there must be a judgment. Our Constitution guarantees fair access to the courts and judgments within a reasonable time, both for civil litigants, both for criminal litigants. Anybody approaching the judicial system should have some certainty that the case will not just be decided in a reasonable time, but that the case will actually be decided. It makes no sense to have a court system that at the end of the day does not yield a decision. That's simple. Most litigants, sir, a lot of people when they go to court, they know whether they are wasting time or not. They have some idea of the strength or weakness of their case. And sometimes all it needs is for somebody to say, you are right or you are wrong. Or, we both know you are wrong, so here's how much you have to pay. Most cases do not get appealed. I don't think the public understands that. Most cases, the decision of the initial judicial officer, whether it be a magistrate or a judge, that is usually the end of the matter. People either pay up, work out some other settlement, or the matter is otherwise resolved. So, sir, here's my other issue. It is not necessary that every judgment be written. What these amendments seek to do, or one of the arms or limbs for which you can infer judicial misconduct, is a delay in granting judgments of over 6 months. This does not mean that the judge has to write his reasoned decision within 6 months. It would be good if he did. But once again, in many cases, the decision can be made orally. And quite often, sir, if we are honest with ourselves, by the end of a case, the judge can actually make that decision there on the spot. It is only in very, very technical cases where a complete review of the evidence has to happen that you might need to delay to come back with a reasoned judgment. In the magistrate's court in particular, which is the court of first instance, it's the summary court. That's where justice is supposed to be dispensed very, very quickly. At the end of most cases, the magistrate can, on the spot, say, I find for the plaintiff, or I find for the defendant. But the failures of our Supreme Court system have now started to creep in to the magistrate's court system, where the magistrates are often now reserving judgment. And the magistrates are delaying in bringing back judgments. That defeats the whole purpose for which the magistrate's court exists. It exists technically as a small claims court intended to dispense justice quickly. So although the amendment says that judges have to bring back their decisions in 6 months, it does not go further than that. A judge can give an oral decision. The proceedings in the court are now recorded. You can have CAT transcription, I believe, for the judges. The judge can give his oral decision. It can be recorded. If the matter is appealed and he has to write reasons or give a written judgment, he can then do his written judgment. But what people want is a judgment. Why are we so afraid to get it wrong that we're paralyzed into inaction? There's nothing worse than not giving a decision. And the court system is perhaps the only profession that contemplates from the outset getting it wrong. That's why there are levels of appeal. If the judges got it right all the time or expected to get it right all the time, there would be no need for the Court of Appeal. If the Court of Appeal was expected to get it right all the time, there'd be no need for the CCJ. You create more of an injustice in delaying in giving a judgment for 1, 2, 5, 10 years than you do in giving the judgment even if you get it wrong. Because it can then proceed to the next step. Now, some people may say, you know what, the circumstances, a judge may not always be able to give a decision in 6 months. In an exceptional case, fine. But then there's provision, as the member for St. James North indicated, for an explanation as to why you can't deliver any time before the time expires. Sir, the other correction that was being made by this amendment is that previously, the Prime Minister could only invoke a complaint against the Chief Justice, and it was up to the Chief Justice to make a complaint for misconduct against any of the other judges below him. So this is now expanded. The Prime Minister can actually make a recommendation to the Governor General in respect of any judge. The Chief Justice can make the recommendation in respect of judges below the Chief Justice. So it's expanded that. And judges need not fear. And people need to understand something. The fact that a judge has been cited under this amendment does not automatically mean that they're going to get terminated. Their employment is going to be terminated or they're going to be disciplined. It starts a process. The process requires the Governor General to appoint a committee of not less, including a chairman, and not less than 2 other members. And these 2 other members must have been either sitting judges or former judges in a Commonwealth country sitting in a court of unlimited jurisdiction. So it is not simply that you're going to pull somebody who don't like you from Barbados. We can go outside. The Governor General has the ability to go outside and source as independently as you can, and you want to be careful when citing a judge. It cannot be done willy-nilly. And to be honest, sir, I don't see this as being something to punish a man if he has a decision that runs 7 months or 8 months. Invariably, this will only be invoked, sir, if you have a judge who has a history, a complete backlog that is clogging up the system. And the most well-meaning, pleasant judge is wasting our time and injuring litigants and hampering the process and adding to the backlog when they just don't deliver the decisions. Sir, this also adds certainty to the structure. We keep talking about wanting to make Barbados the commercial hub of the Caribbean. We keep talking about the ease of doing business. We've spoken over and over about where Barbados ranks in the ease of doing business. It may surprise a lot of people to know that in contracts being entered into in Barbados with parties external, once upon a time Barbados was the jurisdiction of choice. So in a contract, you will normally state that this contract is governed in accordance with the laws of a country. If the contract is substantially to be carried out in Barbados with a Barbadian company, it used to be a matter of course that the contract fell under the jurisdiction of the courts of Barbados. Increasingly now, sir, external parties are insisting that the jurisdiction be outside of Barbados. So what this does is also prejudices our commercial sector. Because if we want to assert our rights under a contract, where the contract effectively is being performed in Barbados, the company is in Barbados, the people being affected are in Barbados, but you now have to fly to somewhere else to sue because our courts are not reliable and cannot give the judgments in a timely fashion, you are crippling business. People will actually avoid coming to do business in Barbados because of that. So for those who say 6 months is too short, I say 6 months is not too short when millions of dollars are riding on it. 6 months is not too short where the rights of the individual are concerned. 6 months is not too short where it's a family matter, where the emotions of the parties are tied up and it can turn to violence. 6 months is not a short time to render a judgment. And it only becomes a difficulty if you keep falling back. Sir, if the new judge coming in, whoever's going to be appointed, starts to keep on top of their judgments, they need never have a problem. There was a judge who left Barbados, sir. I will call her name because it's in a good context. Justice Maureen Crane Scott, who I believe was one of the best judges we ever had in Barbados. One of the best judges I appeared before. Every single matter I had before her, I received a judgment in. When she eventually left Barbados to go and sit, I believe, on the Court of Appeal in the Bahamas, because
That is correct, sir. In the Bahamas, that's
in the Bahamas, as good as she was, she could not get on our Court of Appeal. She went to sit, she gave her notice, frustrated with the way the system was working in Barbados, and she went along. When she left, she did not have one outstanding judgment, not one. Every single case before her for which she was responsible was resolved, dealt with, adjudicated, and the judgment given. If it can work for one, it can work for all. It has to work for all. Sir, I will say there's a lot at stake. The confidence in our judicial system has been eroded. The backlog, sir, has reached what I actually would call this crisis proportions. I left practice, sir, to come to these hallowed halls, and I have judgments that still have not been given. I have to get other people to try to get those judgments for me. And they're important to me because when the judgment is given, I can finally get the money that I worked for years. No, I'm being serious. Let's be very serious. In many instances, lawyers in Barbados will do cases for litigants where the litigants can't pay and the lawyers agree to accept the money at the end of the day. So you have, people may talk a lot about lawyers, sir, but at some point in time you have to defend some. There are a lot of poor people in Barbados who have gone before the courts and who have had their matters ventilated, and they've had them done so because lawyers work with them to try to get them the justice that they required. So when we don't give judgments, we put people's businesses and livelihoods in trouble, not just the lawyers, the litigants. If I am waiting, sir, for a judgment in a personal injury claim where I expect to get $100,000 and the bank is about to sell my house and I keep going, and this has happened, and the people keep going, sir, even in cases where the judgment has been given and you're waiting for quantification of damages and you're telling the bank, listen, this soon coming on, hold on, this soon coming on. And sometimes the banks work with you, but eventually the banks have a business too. So when you stop somebody from getting the money for their injury, it affects every other part of their life. They can't work, they're dependent on that money. They may lose their house, they may lose their car, their wife might divorce them.
For sure.
Sir, I'm not making a personal reference to anyone in this chamber, sir. All I would say, sir, is there's actually way too much at stake. We, as a government, have tried to do everything that we could in a short space of time to put the infrastructure and the facilities in place that the courts can function properly and efficiently. We have done our part. It is now time, sir, for the judges in whom we repose so much trust to do theirs. So, in light of that, sir, I entirely support all of the amendments, and I hope that my explanation in relation to the provisions for the judges has made some sense and clarified some misapprehensions of other people. And with those few words, sir, I entirely support the amendment.
Honourable Member for St. Joseph.
Mr. Speaker, I rise, perhaps unusually, to wrap up this bill in circumstances where the honour was the Prime Minister's to lead off the debate on this very important matter. I truly appreciate the interventions of all the members of the Chamber, and they have been so comprehensive that it means that in my wrap-up, sir, I need not tarry too long. But there are a few points that I would want to make, especially given that the judiciary and how they function is directly connected to my own ministerial responsibility. Sir, it was not an easy thing to propose to Cabinet that we should amend our Constitution and expand the grounds on which an individual could be removed from the bench. I only have one career, one professional career that is, as a lawyer. And I would like to think that I personally know all of the members of the judiciary. In fact, it is a little known fact that the Chief Justice and I used to be musicians and play in the campus band back in the 80s. He was a lecturer in law playing bass guitar, and I was a student in law not playing tambourine, playing rhythm guitar. And I am able to say that some of the judges, older than I am, but have over the years enjoyed very cordial relations with them. And it is always a difficult thing when people perceive that you are doing something to cause them a disadvantage. So it has not been easy for me, or perhaps for any of the lawyers in this chamber, to make a decision that we would want to support this particular limitation. But the fact of the matter is, sir, that we have to push past the sentiments which arise out of friendship and collegial relationships, and accept that in the same way that every other person in this society is accountable for the duties that they're called on to perform, that judges really are no different. And the Constitution sets the ground rule. The Constitution has always provided that if a judge is unable to perform his work, or if a judge is guilty of misconduct, he or she can be removed from office. That exists today and has existed from the day of the passing of our Constitution, sir. And so grave a responsibility is it that the circumstances not only are circumscribed to inability through illness or otherwise, or to misconduct, there's a very extensive tribunal process which must be gone through in order to achieve the removal of a judge. And what is more, sir, in 2003, the Parliament of Barbados added another level of supervision, and that is the Caribbean Court of Justice. So that even if a tribunal reviews the particular facts and determines that based on their opinion, the question of the removal of a judge from office should be taken, They make a recommendation to the Chief Justice, to the Governor General, who must then refer that matter to the Caribbean Court of Justice for ultimate decision. I heard the Leader of the Opposition speak, and he seemed to have some view that this process, the process of removing a judge from office, is one that could be tainted with politics. Not so, sir. Not so. Apart from the tribunal, I reiterate that the final decision really rests in the hands of the Caribbean Court of Justice, people who are of impeccable reputation and who we rely on every single day to make decisions about our domestic matters and to make decisions as the court of, what is it?
Final.
No, that's when we appeal. But they're also the court to hear, court of original jurisdiction. So if we can accept that that court can rule effectively on matters like Shanique Murray and rule on disputes between Barbados and other states and rule on appeals, sir, then it seems a little absurd to me that we could not have the confidence in them to make a determination on the suitability of a person for office. There's no political involvement there. But let me try to explain to this chamber, through the words of the same Caribbean Court of Justice, the gravamen of the situation. In a matter which we call Walsh, decision given in 2016, the Caribbean Court of Justice felt compelled to write about 4 paragraphs in that decision. The case is actually Walsh against Ward, to do with land in St. Lucie, I believe. And the Caribbean Court of Justice felt compelled to speak in clear terms on the matter of delay, not generally across the region, not in the courts of Trinidad or Jamaica or Belize or Guyana, but they spoke specifically about the delay in Barbados. And I know, sir, that you wouldn't want me to labor too much, but I feel I need to read these 4 paragraphs. They're not long, sir. And the court said this in its decision. Regretfully, at paragraph 68, regretfully we are forced to comment once more on the excessive delay that characterizes many cases coming to us from Barbados, sir. That's the first sentence. Regretfully, we are forced to comment once more on the excessive delay that characterizes many cases coming to us from Barbados. These proceedings commenced in 1998, some 17 years ago. 17 years ago, the substantive hearing in the High Court commenced on the 7th of February 2000, and after a 3-week hearing, the trial judge reserved judgment, February 2000, sir. After several requests for the delivery of the High Court judgment, the trial judge finally gave his decision on the 8th of June 2005. A 3-week hearing in the year 2000, and decision is given in June 2005. More than 5 years after the substantive hearing, the court observed. Ward filed his appeal in relation to the High Court judgment on 18th July 2005, and the appeal was eventually heard on the 20th and 21st of September 2011, over 6 years later. To be fair, that's when the appeal was heard, and what we're talking about here is delivery of judgment. So that delay is not that's a delay of the system that we have to wrestle to the ground too. But it goes on. Over a year later, the Court of Appeal issued its judgment on 20th November 2012. This type of delay imposes hardship on the litigants. This is a case where the hardship is obvious. The delay also reflects adversely on the reputation and credibility of the civil justice system as a whole and reinforces the negative images which the public can have of the way judges and lawyers perform their tasks. I would remind you, sir, that in the debate earlier today, dealing with bail, I made reference to a decision Hall, the Queen against Hall, where the Chief Justice of Canada said, people look to the courts. They look to the courts, sir, for protection. The judge goes on. The unfortunate frequency of our lament suggests that the problem is systematic. In Barbados, where the Fusion Service Limited against Merchandani, President de la Bastide, as he then was, said, "We would be failing in our duty if we did not express our strong disapproval of judicial delays of that order. They deny parties the access to justice to which they are entitled and undermine public confidence in the administration of justice." That's the chicken and ram case, I believe, sir. And another Barbadian appeal, Yolande Reid against Jerome Reid. Saunders J. said, "This is the second time we have had occasion to call attention to inordinate delay in the delivery of judgments in Barbados." Not in St. Lucia, sir, in Barbados. We trust that effective remedial action, if not already taken, will now be taken to ensure that judgments are delivered within a reasonable time as required by the Constitution of Barbados, sir. In Sea Havens Inc. against Dyrud, Hayton said, another judge, "This is a most unsatisfactory situation that needs to be remedied, and we trust that the new civil procedure rules will considerably improve matters." Didn't happen, sir. In Colby against Felix Enterprises, Hayton referred to an approach in the English court where the English judge said this extraordinary delay clearly called for an apology, and if any existed, an explanation of the mitigating circumstances. In System Sales Limited, another Bajan case, President Sir Dennis Byron noted, "The court deplores the fact that parties are denied justice in a timely manner and recalls that this must bring the administration of justice into disrepute and undermine public confidence. The consistent need for the repetition of this disapproval and over such a long period of the delays in the system, accompanied by calls for remedial action, makes the situation extremely deplorable. Reaction can no longer be put off," he says. "This is an aspect of the judicial role for which there should be accountability. We urge the judiciary to take steps to address the problem of delay in the judicial process and ensure that citizens enjoy the benefit of the constitutional promise of a fair and expeditious resolution of disputes." Sir, that extract from the Walsh and Ward decision would cause any right-thinking member of the Barbadian society to cry shame on the functioning of our judicial system. These are distinguished international jurists who repeatedly have found it necessary to draw attention to delays in our judicial system, which they describe as obviously being systemic. And instead of grappling with the situation, sir, we've had excuses. Our last Prime Minister said, as far as he was concerned, he was going to come out of the Caribbean Court of Justice because they are slandering Barbadian judges and criticizing us wrongly. That's what he said, our former Prime Minister. That's what he said, sir. Did not put an additional judge on the bench, did not do a single thing to improve the administration of justice, but just complained that the CCJ talking badly about us. Sir, everything that the CCJ has described there has been and is factual. So we have a choice. We could say, well, we could try and pick at it, or we could do all kinds of things, sir. But you know what? We have judicial officers who have in excess of 25 decisions to deliver. Now, Mr. Speaker, if I were a litigant and I had invested my time and my effort in fighting a case, sir, it is because me and the other side have a dispute that we cannot resolve among ourselves. And we've decided to have recourse to the constitutional mechanisms which are in place in an orderly society called a court. And a court, sir, has a responsibility to sit. And in this context, that is a term of art. But what it means is that every judge has a legal obligation to hear matters and to dispose of those matters. So sitting doesn't mean you come and sit on the bench and have lawyers come and talk. The duty to sit includes, as an inextricable part of it, the disposition of the case, sir. Now, this has been going on for too long. And as I said, sir, this is not an easy place to be, because I believe that the other lawyers in here consider many of these individuals to be friends. And it just occurred to me that at least one of them considers one of these individuals to be a spouse. So these are not easy things to do, sir. But throughout the dicta of the CCJ, there is that golden thread of accountability, sir. Mr. Speaker, you're accountable. I am accountable. Clerks at the bar, at the table, are accountable. Everybody is accountable, sir. And all that we're saying is that our judges need to be accountable to the people and the system that they serve. Mr. Speaker, the issue is not whether you can write a decision in 6 months. In fact, sir, the CCJ and other courts have repeatedly said that only the most complex of cases should take you more than 3 months to write. Only the most complex of cases should take you more than 3 months to write. There is a code of judicial conduct that all of our judges have signed on to, where they agree that they will deliver judgments within 8 months of hearing the matter. Within 8 months, sir. But we can have a judge who has retired and gone on home, and there's a decision that he still has not given. I only mention that because that really is an extreme case. But I know of one in particular. But we have judges with decisions that are outstanding, sir, for 5 years.
Trust me, more than that. Honourable, trust me, more than that.
We have
more
had
than 5
instances,
years.
sir. We've had instances, Mr. Speaker, where people have had to bring constitutional motions against the Crown because of delays in giving decisions. We've had instances, sir, where individuals have died, and either the case cannot be completed or they have lost the fruit of any decision that is given, sir. There is no other aspect of our society that we would accept this kind of situation. None. There's none, sir. Somebody goes to the casualty, and if they wait half an hour, they call in the member for St. Andrew, the member for St. Joseph, to get a hold of this body. I had the casualty here too long. But somehow the rest of us are supposed to accept that delays in the delivery of judgments is right. It is wrong. It is wrong, and as a parliament, it is important that we send a signal. It is not about how long it takes to write a judgment. It is about how long it takes you to deliver your decision. There are numerous instances throughout all of our legal education. You see sometimes that the judge gives a decision and says to the litigants, we can render a written decision if it is required. Many matters can be disposed of in that way, sir. Many matters. And you know what is surprising is that when these judges sit on the criminal bench and the matter is heard, they don't adjourn for 5 years to come back and give a summation to the jury. Generally, the summation to the jury of sometimes evidence of 30 and 40 people is done within a few days. Within a few days, sir. But in the civil jurisdiction where now you have written, where you now have written submissions, skeleton arguments, all these things, everything is there, sir. Mr. Speaker, the process to the removal of judge, so far as I'm aware, has never been undertaken in Barbados. And I hope to God that it never is. But there's nobody who could say that we're being unfair to anybody because we are increasing the number of judges. We are helping to get rid of the backlog. We're creating more courts and specialized courts, sir. All of these things we in the executive and the parliament are doing so as to ensure that justice is delivered with all possible dispatch. It is only fair, sir. It's only fair that on the other side of the coin, we should say to our judges, meet us, not even us, meet the people of Barbados halfway. Mr. Speaker, I will not trouble the chamber to speak on the other elements of the Constitution Amendment Bill dealing with the public service. I believe that the Prime Minister and others have dealt with that admirably. I can only say that to whom, there's that old adage, to whom much is given, from him much is expected. Our judges are in a very rarefied element. Few people in our constitutional arrangements have the kind of protection that they have. They have protection which says you can't alter their terms and conditions. You basically, in order to remove them, you have to go through all kinds of processes. And sir, you know, all we're asking the judges to do is to honor their commitment to do justice to the people of this country by giving decisions and giving them in a reasonable time. When we set up a commercial court, the nature of commercial court work has to be that decisions are going to be given, have to be given quickly. Have to be given quickly, sir. So I'm obliged to the members of the chamber for their support for this bill. This too requires, as you are aware, an amendment to the Constitution, and we look forward to your support. I commit not just to the public of Barbados, but to the judges as well, sir, who I'm sure work hard. We're going to give them everything that they need, but the people of Barbados need justice, and justice delayed, sir, is always justice denied. I'm obliged to you. Yes, Mr. It's already been moved. I'll do it again. Yes. Mr. Speaker, I beg to move that you do not leave the chair and that this House resolve itself. Sorry?
Second time.
I beg to move this bill be read a second time.
Like second time.
But that was already done.
Question is that this bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Beg to move that you do not leave the chair and the House resolve itself into committee for further consideration of the bill.
Question that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This House is now in committee.
One.
Beg to move that clause 1 stand part.
Question is that clause 1 stand part. All honorable members in favor, please say aye.
Aye.
All honorable members against, please say nay. Methinks the ayes have it.
Clause 2.
Beg to move that clause 2 stand part.
Question is that clause 2 stand part. All honorable members in favor, please say aye.
Aye.
All honorable members against, please say nay. Methinks the ayes have it.
Clause 3.
I beg to move, Madam Chair, that clause 3 stand part.
There. The amendment.
We wish to propose an amendment to clause 3, and it is, Madam Chair, that we remove the word in clause 3C, where we have for delay of more than 6 months in delivering a judgment, singular. We wish to remove the a and make judgment plural. So the clause would now read, for delay of more than 6 months in delivering judgments. And the reason for that is so that an individual, it could not be said that for delaying for one judgment that you would face removal.
Question is that clause 3 stand part with
As
amendment. All honorable members in the second. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
In chunks.
Yeah, as you wish.
Clauses 4 to 10.
Beg to move that clauses 4 to 10 stand part.
Question is that clauses 4 to 10 stand part. All honorable members in favor, please say aye.
Aye.
All honorable members against, please say nay. Methinks the ayes have it.
Clauses 11 to 15.
Beg to move that clauses 11 to 15 stand part.
Back to second one.
Question is that clauses 11 to 15 stand part. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
Clauses 16 to 22.
Beg to move that clauses 16 to 22 stand part.
Madam Chair, back to second, please.
Question is that clauses 16 to 22 stand part. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
Report.
Beg, Madam Chair, that you do not report to His Honour the Speaker the passing of one bill in committee with amendment.
Question is that, second? Question is, I now report to the Honourable Speaker the passing of one bill in committee with amendment. All honourable members in favor, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Chairman of committee has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
Question is that the aforementioned bill be read a third time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the Constitutional Amendment Bill Number 1 Act of 2019. Aye.
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 Aye. Aye.
Bessie.
Aye. Mr. Sullivan? Aye. Ms. Husbands? Aye. Mr. Abrams?
Aye.
Mr. Weir?
Aye.
Mr. Ford? Aye. Mr. Thorne? The Constitution. Bill is duly passed.
This bill is passed and so cited.
Recommittal of papers, sir. Okay. Documents related. Committee, commanded to the corporate affairs. Yeah, go for it.
Honourable member for St. Michael North.
Mr. Speaker, I'm commanded to lay the Corporate Affairs and Intellectual Property Office Business Plan 2019 to 2020.
Honourable member for Christchurch East Central.
Mr. Speaker, I'm commanded to lay the quarterly report on state-owned enterprises for the quarter October to December 2018.
Recommittal of statements by ministers.
Honourable member for St. Michael North.
Pedro, I can get the thing. I can get the thing. You think to read? Yes. Further. Mr. Speaker, this ministerial statement concerns the development of initiatives to strengthen the Corporate Affairs and Intellectual Property Office with a view to providing greater efficiency and effectiveness of that office. The department's mission is to provide and maintain, within the framework of the law and the available resources, a reliable system of public records and an efficient registry service which supports the commercial activities of the public and private sectors, as well as the development of Barbados' domestic and international trade and business. Mr. Speaker, this government is committed to entering into a public-private partnership to outsource the management of operations at KAIPO. This partnership will provide greater efficiency and timeliness in the registration of new businesses and the operations of KAIPO generally. It was originally envisaged that certain arrangements would have been in place by the beginning of this new financial year. However, it is now expected that these reforms will instead take effect during the first half of the financial year. In the interim, the officials at KAIPO thought it prudent to prepare a business plan which would implement some needed adjustments and improvements to that office pending the commencement of the proposed partnership. The goals and objectives of these initiatives are to improve the operations of the corporate registry through improved technology and the effective utilization of the optimum staffing levels to bring about the following changes: processing of business name searches and reservations, same-day response; processing of applications for the incorporation and organization of companies and societies, 1 day provided that the applications are in order. Registration of companies as external companies, 2 days, provided that the applications are in order. Registration of business names, same day. Processing of applications for the issuance of a registrar's certificate or certificate of good standing, same day. Processing of post-incorporation filing of records, 5 days. And processing of post-incorporation changes, for example, debentures, bills of sale, and business names, 3 days, Mr. Speaker. In 2015, an e-filing platform was introduced at the corporate registry to facilitate the electronic filing of applications for the registration and incorporation of businesses and corporate entities, the examination of applications by the officers of the corporate registry, and the registration or incorporation of businesses and corporate entities by the registrar of companies, evidenced by the issuance of a certificate of registration or incorporation. However, the facility stopped short of full electronic processing, as the certificate is presently being physically signed by the approving officer for issuance. This is to be rectified, Mr. Speaker, by mid-April 2019. Further, currently it is only possible for local entities and persons to make payments directly online. It is our intention to be able to allow online payments from our overseas clients as well. This is expected to be remedied with the proposed government e-payment platform, which would allow the users to review all of their obligations to the government of Barbados and make payments as required. Payments will be done via the web application using direct debit or credit card via a payment processor. The e-payment platform would allow the customer to have a full view of all obligations and payments made to the government of Barbados, regardless of the channel used for payment. This is expected to result in an increase in business as well as revenue. It is recognized that the current level of human resources at CAIPO is resulting in the underperformance of the corporate registry. Accordingly, going hand in hand with the improvement in technology will be the provision of adequate staffing levels throughout the registry to strategically refocus it to achieve the intended results regarding the timelines in registering all business entities. The redeployment of the staff complement, both legal and administrative, will also ensure that the requisite skills and proficiencies are assigned to the most vulnerable areas of the corporate registry, thus generating greater immediate positive outcomes. Our aim is to ensure that improved business facilitation results in increased revenue and an overall improved experience at CAIPO. A business plan has been prepared for the Corporate Affairs and Intellectual Property Office, and I lay a copy of this document here today. We do strive to make our Corporate Registry and Intellectual Property Office the best that it can be while servicing Barbados' domestic and international trade and business. Thank you, Mr. Speaker.
Honourable Member for Christchurch East Central.
Mr. Speaker, this is a ministerial statement on the reform of the state-owned enterprises. As you are aware, Barbados has developed a homegrown economic program which is being supported under the International Monetary Fund's Extended Fund Facility. One of the key elements of this program is the reform of state-owned enterprises. The state-owned enterprises in Barbados currently consist of 58 entities. Of this amount, 37 are being classified as commercial state-owned enterprises, while the remaining 21 have public service and regulatory objectives and are being classified as non-commercial state-owned enterprises. Normally, transfers from central government to state-owned enterprises are extremely high. and are a major contributor to fiscal risk. We are therefore aiming to reduce these transfers by a combination of much stronger oversight of state-owned enterprises, improved reporting, cost reduction, revenue enhancement, and mergers and divestments. A number of state-owned enterprises are being reformed under the Extended Fund Facility Program and will be closely monitored through structural benchmarks, allowing for timely implementation of additional measures should slippage occur. One of these structural benchmarks is the requirement that a standardized quarterly financial report be laid in Parliament. The quarterly report at December 31st, 2018 reports on 51 state-owned enterprises out of 57 that are being monitored, which represent a 90% compliance rate. Some 6 state-owned enterprises have therefore not complied, and this is a clear contravention of the directives from the Director of Finance and Economic Affairs, which stipulates that state-owned enterprises were to report their quarterly financial information by the 5th of the month following the end of the quarter, as well as submit restated financials at December 31st, 2018 in respect of the write-off of intergovernmental arrears. The report summarizes the aggregate performance of the state-owned enterprise sector for the quarter, with their fiscal position being impacted by the government's write-off of transactions occurring between the state-owned enterprises and central government, which affected outstanding amounts for receivables, payables, and loans. The analysis of the data suggests that the state-owned enterprise portfolio to a large extent had underperformed during the quarter, and this was demonstrated in the ratios for profitability, liquidity, and debt, which were predominantly below the acceptable benchmarks. On the surface, Mr. Speaker, the third quarter marked an encouraging period for the state-owned enterprises in terms of performance, with the entities reporting an aggregate net profit of $186.82 million. The commercial state-owned enterprises were the major contributors, accounting for 92% or $171.77 million of the total, while the non-commercial state-owned enterprises accounted for the remaining 8% or $15.05 million. However, these profits earned by the state-owned enterprises were largely as a result of the intergovernmental write-off exercise, which resulted in a number of the state-owned enterprises posting to other income the payable balances that were written off. This one-off transaction had the effect of increasing the overall revenue totals for the quarter. Excluding the write-off, the non-commercial state-owned enterprises would have reported a net profit of $1.86 million, while the commercial entities would have reported a net loss of $14.20 million. The entities identified for reform reported a net profit of $117.42 million for the quarter, with the results being largely influenced by government's grants as well as the write-off. A net loss of $161.01 million would have been recorded had the government subvention and the write-off of interagency balances been included. There were 5 top profit earners within the group: Barbados National Oil Company Limited and Barbados National Terminal Companies Limited Consolidated, Caribbean Broadcasting Corporation, Barbados Agriculture Management Company Limited, National Petroleum Corporation, and the Queen Elizabeth Hospital, which reported profits totaling $77.17 million, $44.12 million, $34.69 million, $19.18 million, and $14.03 million, respectively. However, without including government grants and the write-off, only 2 of these 5 state-owned enterprises would have recorded their profit, namely the Barbados National Oil Company Limited, $2.14 million, and the BAMC, sir, $1.13 million. Conversely, there were some significant loss makers, namely the Barbados Tourism Marketing Inc., the Transport Board, and Caribbean Aircraft Handling Company Limited, with reported net losses of $7.69 million, $7.12 million, and $5.25 million, respectively. As previously mentioned, the analysis of the financial ratio showed a concerning trend of low levels of liquidity across the large portion of the state-owned enterprise sector, particularly within the commercial state-owned enterprises, where it was shown that this group recorded a working capital deficit of $65.08 million. Approximately 20 state-owned enterprises recorded current ratios that were just slightly above or below the minimum acceptable benchmark of 1, ranging between 0.07 and 1.40. The Student Revolving Loan Fund, Fund Access, Enterprise Growth Fund Limited, and Caves of Barbados were the main exceptions to this trend, as these entities recorded significantly high ratios of 173 to 1, 43 to 1, 25 to 1, and 19 to 1, respectively. The analysis suggests that liquidity was largely suboptimal, especially within commercial state-owned enterprises, and to a lesser extent within a number of the entities included in the group in the Extended Fund Facility Program. This situation could lead to the state-owned enterprises accumulating arrears, which has the effect, sir, of increasing the government of Barbados' exposure to financial risk. The debt-to-equity ratio at the aggregate level stood at 1.93, placing it above the traditional benchmark of 1, and suggested that for every dollar in equity, the group had $1.93 in debt. Within the commercial and non-commercial state-owned enterprise portfolio, however, there was a level of contrast. The commercial state-owned enterprises recorded a high debt-to-equity ratio of 2.10, while the non-commercial entities' debt-to-equity ratio was favorable and stood at 0.65. Further, regarding entities identified for reform, the debt-to-equity ratio was relatively high at 1.68. However, given the debt restructuring exercise is still ongoing, and this is expected to address this area, it is therefore important that state-owned enterprises continue to be closely monitored to ensure that these financial challenges, when corrected, do not reoccur. Two other areas of concern relate to some entities' over dependence on government and to the cost recovery ratio. Government subventions and grants were shown to be an important contributor to the total revenue of the state-owned enterprises, accounting for 30% of the aggregate total revenue. In the commercial state-owned enterprises, government subventions represented 22% of the revenue. This is in contrast to the non-commercial sector, where the contribution of government subvention was substantial, accounting for 65% of their revenue. Operating revenue, sir, as a percentage of operating expense, which is the cost recovery ratio, was slightly below the benchmark and stood at 93% for non-commercial entities, 90% for commercial entities, and 97% for all the entities in the program. This suggests that these entities were not generating enough operating income to cover their operating expenditure. Regarding the commercial entities, this indicator was especially concerning, as this sector should be more profit-focused. At least 10 commercial entities had cost recovery ratios of less than 50%, with 4 of these having ratios of 0. The above largely indicates that cost recovery is generally poor in the state-owned enterprise sector, and underscores the importance of the need for a thorough review of the tariff and user fee structures to address this peculiarity. The identification of areas where costs can be streamlined would also contribute to improving the operating performance of the state-owned enterprises. Mr. Speaker, sir, the arrears of state-owned enterprises is an issue that has plagued the country for a number of years. This issue was of significant concern to the government as the size of the deficit was directly impacted by these arrears. The government, in its attempt to address this issue, has instituted a number of measures to clear a significant proportion of the arrears held by the state-owned enterprises. Initiatives that were introduced include the arrears of the 5 major state-owned enterprises suppliers as part of government's debt restructuring program, writing off intergovernmental transactions occurring between state-owned enterprises and other public sector bodies, and the government offering discounted settlements to suppliers for arrears occurring prior to September 30th, 2018. For the latter measure, state-owned enterprises were instructed that the arrears were not to be liquidated by them and the balances were to remain constant until the government settles the amount. The state-owned enterprises were also instructed that they should no longer be accumulating arrears from the aforementioned date. The data, however, largely suggests that there are still a few issues with regards to the management of arrears, but these are being dealt with accordingly. Although a number of reasons have been cited for this, it is unacceptable as it can derail the program if not stemmed. One of the major highlights within the state-owned enterprise sector relates to the impending enactment of the Public Finance Management Act. This legislation is scheduled to be proclaimed shortly and shall provide the government with a strong legal framework that will target the areas of deficiency within the state-owned enterprises that include gaps in accountability, transparency, and fiscal prudence. The standardization of the financial reporting within the state-owned enterprises is also an area that is to be addressed, and this would have the dual purpose of assisting in improving the comparability of the state-owned enterprises' financial statements, as well as improving on the quality of financial data and accompanying notes being submitted. Efforts are also being undertaken by the government to accelerate the completion of the audited financial statements of the state-owned enterprises, where a considerable amount of them are in backlog. This exercise, which is also a key requirement of the IMF-supported program, would greatly assist the government as the owner and shareholder of the state-owned enterprises to obtain better assurance with regard to the reliability of the information contained in the financial statements. A consolidated database will also be developed to ensure that information is more timely and accurate. Unfortunately, the analysis of the data suggests that the state-owned enterprise portfolio, to a large extent, underperformed during the quarter under review, and that the financial performance was weak at both the aggregate and within the groupings. Additionally, although it is appreciated that a lot of work is being done on the financial analysis side, the risk management and non-financial areas will need to be strengthened. It is apparent, therefore, that despite the strides that we have made, there's still a lot of work to be done. I'm obliged to you, Mr. Speaker.
Revert to government business, sir. Order number 2. In the name of the Honourable Minister in the Ministry of Finance, to move the second reading of the final appropriation 2017 to 2018 Bill 2018.
Honourable for Christchurch East Central.
Mr. Speaker, I beg to move that this bill be read a second time.
Thank you, Senator.
Question is that this bill be ready a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that you do not leave the chair in the House Resolve at 7 committee for further consideration of this bill.
The question is that the Speaker do not leave the chair and the House resolve at 7 committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This House is now in committee.
Clause 1.
Madam Chair, I beg to move that Clause 1 stand part.
Question is that Clause 1 stand par. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
We will call it. Clause 2.
Madam Chair, I beg to move that Clause 2 stand part.
Question is that Clause 2 stand par. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
Clause 3.
Madam Chair, I beg to move that Clause 3 stand part.
Question is that Clause 3 stand par. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
Clause 4.
Madam Chair, I beg to move that Clause 4 stand part.
Question is that Clause 4 stand par. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
The schedule.
Madam Chair, I beg to move that the schedule be the schedule to the bill. Sorry, that is, yes.
Question is that the schedule be the schedule to the bill. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
You mean actual name? At 2019. Madam Chair, I beg to move that you report as on the Speaker the passing of one bill in committee.
Go back to Clause 1. There's an amendment at Clause 1.
Sorry. The amendment at Clause 1, Madam Chair, relates to the name of the bill. I'm asking for the amendment for 2017 to 2018 in 2019.
The bill should now be cited 2017 to 2018 at 2019.
Right, Madam Chair, the bill should now be cited as the final appropriations bill 2017-2018 at 2019 as opposed to 2018 as
Question is that Clause 1 stand par as amended. All honorable members in favor, please say aye. All honorable members against, please say nay. Methinks the ayes have it.
Madam Chair, I beg to move that you now report to the Speaker the passing of one bill in committee. With amendment.
Question is that I now report to the Honourable Speaker the passing of one bill in committee with amendment. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Let me find it.
Chairman of committee has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
Question is that the aforementioned bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. Meeting the ayes have it.
Mr. Speaker, I beg to move that this bill be now passed and cited as the final appropriation 2017-18 at 2019.
Question is the aforementioned bill be cited and so passed. All those honourable members in favour, please say aye. Those against, please say no. Meeting the ayes have it. This bill is so passed and so cited.
Mr. Speaker, that brings us to the end of government business for the day. I beg to move that the House be adjourned until Tuesday at 10 a.m. in the forenoon, Tuesday the 9th of April.
11
11? Is it 10 a.m.? 10 a.m.
question is that this aforementioned House be adjourned, that this Honourable House be adjourned until the 9th day of April at 10 a.m. in the forenoon. All those honourable members in favor, please say aye. Those against, please say no. I think the ayes have it. Before we stand adjourned, I wish to inform this honourable chamber that I will be out of the jurisdiction from the 4th day of April until the 12th of April. I'll be attending the 140th Interparliamentary Union Assembly in Qatar, which will examine the role of parliaments as platforms to enhance education for peace, security, and the rule of law. I will be accompanied by the Clerk of Parliament and also Senator Damian Sands from the Senate. In my absence, obviously, the Deputy Speaker will stand in the chair in my stead. This House will now stand adjourned until the 9th day of April at 10 a.m. in the forenoon.